Lordship, I beg to mention the item number 3. Lordship, conducting counsel A. Tatak is at medical.
Huh?
Conducting counsel A. Tatak is at medical, Lordship. His wife is admitted, yesterday admitted at hospital, so he is unwanted.
On the prayer of
GT Raju, GT Raju.
Niti Raju, learned counsel for the appellant on the ground that Mukpartin,
No,
who is conducting counsel?
Adam Tatak, A. Tatak.
Hmm?
A. Tatak.
A.
Tatak, Adam Tatak.
A. Tatak, learned counsel is having some personal issues, personal problem, and the prayer not being objected to by Mr. D. Loy, learned, and is the learned public proceeding. Let this matter be listed after 4 weeks.
Your Lordship, after a week.
Huh?
After a week, after 1 week.
Not after. After 3 weeks.
Deeply, Your Lordship. May Your Lordship.
Yes.
I have filed one IA for correction of cost title and adding of paragraph in the prayer section. Your Lordship.
Yes.
Yes, as per the order dated 29/05, I have filed one IA regarding amendment of the cost title
Where is that order?
in page 11, Lordship.
So,
Respondents are appearing.
Yes,
You have
ma'am.
received a copy.
I've received the copy.
so any objection?
No, madam, no objection.
Heard Mr. So-and-so, the counsel for the applicant, public applicant. And also Mr. MS. So-and-so. For respondent number 4.
I'm board respondent number 2, C is for 4.
Respondent number 2. Who is PP? PP. D. Loy, respondent, learned public prosecutor, comma, Mr. L. Kurdu, learned special PP, within bracket SIT. And MS so and so forth. Respondent number 4. What about the others?
The other did not come because of the loan property.
Although no notice. No, having considered the nature of prayer made in this application, we deem it appropriate. No, we have reviewed that no notice is required to be issued to the other respondents. Other respondents. And the application is disposed of at the Mason stage. Next paragraph. it is seen that the applicant has inadvertently no. The appellant has prepared the criminal appeal being CRA number 1 of 2025 against the judgment and order dated the judge. Where the judgment and order? Which state?
36(9).
Hmm?
Yes, sir.
Judgment and order and sentence dated 26/09/2025 was by the special judge within bracket Fox, bracket clause, by UPA. Convicting the applicant appellate and sentenced to rigorous imprisonment for a term of 7 years. You take this para one sentence different under section so and so, different sections. Para one. Well, filing the above appeal, the petitioner, the appellant has inadvertently, no, incorrectly mentioned the appellant instead of the appellant being Sri Tabum Tapir instead of the appellant Srimati Marbom Mamdek Tapur. It is also said that the application, the applicant seeks to delete the para 12 of the appeal, said appeal, and for an additional prayer in the prayer portion of the appeal. Next prayer, having considered the application that the petition applicant has inadvertently incorrectly mentioned the appellant. Also considering that the certain the paragraph 2 of the appeal is sought to be deleted thereby, and also to add certain prayer in the prayer pursuit. Whereof the view that we deem it appropriate to allow this application. And then before that, and prayer not being objected to by learned counsel to the respondents. We deem it appropriate to allow this application. As we find that the correction of the deletion and adding and the appeal shall not cause any prejudice to the respondents. Accordingly, the application is stands allowed. And accordingly, the petition applicant is allowed to correct the name of the appellant, comma, to delete the end of the prayer, the paragraph two of the say that it is deleted, and the applicant is allowed to add the prayer in the prayer portion being question satisfied. As under, question satisfied, the judgment the order of sentence dated 26/09/2020 passed by the special judge Boxer, UPL, convicting the appellant Srimati Umarpal Mohammed Tapir. Which is a distance allowed. No, listen. The applicant to file that will be or amended. You have to file corrected amended appeal. So the applicant, public appellant to file amended petition of the criminal appeal. Listen. I stands.
My lord, with all humility, I respectfully submit that on the last occasion when this interim order was passed, my lord, it was passed because of its interim order. I have observed, my lord, in effect, it amounts to permission giving to proceed with the DPC
Yes,
under the impugned rule, but which is the subject matter.
that is our view. Unless we stay the rules, amended rules, we cannot stop the DPC. Sorry, where is it? Also, we'll keep it pending.
But
Second day last of this.
My lord,
So what to pass, don't want to pass any.
my lord,
adverse-
I pray that this IA may be disposed, my lord. This way, that way, my lord.
Why?
I have a reason, my lord. Because, my lord, there is an interim order already passed by Honorable Justice Abu, saying, giving a liberty that if they can, they want to consider, they can consider as per the 2006 rules. But there is no stay in the DPC proceedings.
But sitting in the appellate court.
Yes, my lord, but there is no stay as such. Yes, there is no stay as such.
No, we're not going into all this. What he's saying is for modification of our order only.
Yes, my lord.
So we're not inclined to modify, that's all.
but there is another aspect, my lord.
The rule is under challenge. And we have not stayed the rule.
Yes, my lord.
Until I stay the rule, cannot stop that.
Well, by a forwarding, what they have portrayed as if that if the DPC wants to
Sir, it's a matter of.
My lord, there is
Before that.
my lord, there is another issue. My lord, in 315, which was taken up yesterday also,
Hmm.
where implement of the private respondents were allowed. My lord, in that case, in that case, we have sought for implementation of the rules 2006 because the DPC.
It's a matter of.
Malad.
Single bench.
Yes. No, my
Or
lord,
in
my lord,
division bench.
there will be an issue, my lord. Yeah, that is what I'm trying to point
You
out.
raised that before the appropriate time.
No, my lord. Here, supposing if this rule is allowed to be implemented.
You are not
which is-
staying for the rules unless we stay the rules. And normally we don't stay the rules. Because the presumption is its constitutionality
No, my lord, in that case, my lord.
until the time we
My
decide.
lord, there will be a difficulty. Why I'm pointing out is that in 315, the 19 post, his lordship has given liberty to consider filling up those posts on the basis of 2006 rule, on the ground that the DPC process has already begun in 2023, but then that has not culminated into any finality. That's on that ground. But if this is implemented, there might be an attempt to even fill up those 19 posts.
We'll see, nobody is stopping you. You come back if there's anything in future. And as of now, so far as this IA is concerned, we're not inclined.
But otherwise, one small clarification that let it be
Subject to outcome. You are protected. In case you, we allow your writ petition, consequences will follow.
well, there will be a
Because
lot of
the-
hard bonds.
the-
Well,
No, filling of the
supposing
post promotion will be based on the amended rules only.
Yes.
So in case if we allow your petition, consequences will follow.
that has already been provided.
We have provided because you are
Well, in-
protected because it will be
Well,
subject to outcome.
in case somebody is promoted, and but then our repetition is succeeds. Well, it will be
Yeah.
what I feel is
There we have completed them. They are before this court. They know what would be the
Yeah.
consequences. If it is allowed, your repetition allowed, consequences will follow. Because you will be setting aside this amended rule 5. So that whatever action taken, that's why we feel, according to us, since the rule is not stayed, we cannot stop them. And therefore, we have protected you saying that shall be subject, any promotion shall be subject to outcome. Better you withdraw or will dismiss your.
well, especially the second part that it will not be a bar. Well,
No, that cannot be. We're
If-
not forcing them to think, but at the same time, we cannot stop.
well, this is respectfully,
That's up to
this is
them.
an indication that you go ahead. That is
And
being
they may
considered.
go ahead. Until the time it is rule is stayed. Sorry, sir. Dismiss.
Ballot में decision हुआ।
We will, then we will withdraw.
Because we are not inclined. I have Mr. T. Pertit, Landed Council for the petitioner. They have applicant, writ petitioner, and also her. You are one,
Yes,
Mr. N. Ratan. Then additional.
1 to 4.
Respondent number
1 to 4.
1 to 4.
5 to 16.
5 to 16. Deepak, you
1 to-
said. After arguing the method at some length, Mr. T. Pertit, Land Council for the the writ petitioner. Fairness and that he may be allowed to withdraw this application. Where the application is stands crossed on withdrawal.
उसमें है क्या ये जज ऑर्डर है क्या ज्यादा वो अंदर में ये ऑर्डर है अंदर में ये वाला ऑर्डर वो अंदर अभी का फाइल का है
Yes,
I would like to withdraw my petition.
why?
There is a mistake in annexure 3.
With a liberty,
No, with liver.
heard Mr.
El Murta.
L. Murtab, learned counsel for the petitioner, who submits that he may be allowed to withdraw this writ petition with a liberty to file afresh. Mr. Estafin Learned Senior Government Advocate is present. Praise the Lord. Writ petition stands closed on withdrawal, disposed of on withdrawal with the liberty as prayed for.
Much obliged.
May I please, my lord?
Yes.
Well, in the year 2016, Women Monachal Forest acquired a land in Upper District for the road construction of BKDB Milling Road under section 10 of the JLR. My lord, land acquisition notification as batch number 15. Madam, by office memorandum dated 6/2/2021, the deputy commissioner is authorized to determine the reasonable compensation following the summary procedure. It was agreed to pay landowners with 100% solution and 12% interest. My lord, may kindly see phase number 23.
23.
Yes, page number 23, minutes of summary procedure to
Hmm.
determine. Look at relevant, at page number 25. Page number 25, para 6. Arrive at the negotiate reasonable compensation. The provisions of section 30 of Law Act 2013 has been taken as a base reference only without invoking the act per se to assess the compensation amount along with the numerous and the lost income of the stakeholder. My lord, after that, compensation was disbursed with 100% solution and 12% interest to the landowners. However, my lord, what happened? The petitioner's land was not properly assessed. Therefore, the petitioners filed a representation before the deputy commissioner for re-verification. And in the meantime, my lord, what happened? The commissioner of vigilance directed the deputy commissioner Siang to constitute a technical board for reassessment.
On your application.
Not exactly on my application.
Yes, yes.
There was a allegation of discrepancies in the
Then
assessment.
compensation,
Yes.
assessment, yes.
My lord, accordingly, the board has assessed the petitioner's land. My lord, may kindly see at page number 43.
Yes. Pending nyoto.
Getting your word.
Hmm.
Look here, the amount is 15 lakhs 8,880.
You have received this.
No, not yet received.
Why?
My lord, because they that now that deputy commissioner is saying that they will not pay the 100% solution and 12% interest. So this amount is pending.
So you have refused to receive.
because my lord, they denied to pay the solution.
No, you don't want 15 lakhs.
My lord, I want 15 lakhs with 100% solution.
So you don't want 15 lakhs. You want double of the amount.
Yes, my lord.
So what is the remedy?
My lord, after that, the petitioner filed a representation.
Not representation, reference. For reference, have you filed reference? This is acquired under which law? Land has been acquired under which law?
Section 10 of the JLR.
So. Why are you saying that it is paid under the 2013 Act?
My lord, my friend is
Issue notice, we'll see. We'll issue notice, we'll see.
Yes, Lordship.
Heard Mr. O. Modi, learned counsel for the petitioner. One petitioner.
Yes.
You refuse to accept, receive this amount,
My lord,
15 lakhs.
even because the deputy commissioner are not ready to pay the solution, so the petitioner is denied to accept the 15 lakhs.
Minus the.
Denied or you refuse to accept, been received.
My lord, all the others landowner has been paid
With 100%.
100% solution. So there is a discrimination.
Okay. By filing this writ petition, the petitioner claims for, no, petitioner has pled for
Notification, initial notification.
direction to release the pending land compensation amounting to rupees 150,883. This is 15 lakhs
15 lakhs.
with 100% solution and to pay 12% interest. 12 and to pay interest at the rate of 12% in respect of the land acquired under section 10 of the Balipara/Tirap/Sadia Frontier Track Zoom Lane Regulation 1947 for the purpose of construction of and widening of national highway to double lane specification at Dite Miging Road, Upper Siang District, Arunachal Pradesh. In respect of change number 113.806. Mr. It is the contention of the petitioner that the respondent authorities have paid other landowners in respect of same stretch of land with 100% silicium and with interest of 12%. However, the petitioner has been denied, which clearly indicates the discriminatory action on the part of the respondent authorities. Issue notice returnable by 4 weeks. As
My lord, although the calculation is under the LARA, since the notification is under the Zoom Lane regulation, my lord, the Zoom Lane regulation has been amended and there is a provision for appeal. Earlier it was to the governor, but now it is to the secretary lane after the amendment. If they are aggrieved by any decision of the deputy commissioner, well, even on the quantum, provision is for appeal. Under section 17, under.
let us see next.
Yes, my lord.
As Ms. You are appearing for all.
Yes. Yes, Lordship.
Since MSG at London Edition Senior Government entered appearance exit notice on behalf of all the rest, no formal notice. I will accept copies.
Item number 3.
List after 4 weeks.
Lordship, in this matter, Lordship, I'm being aggrieved by the order of the referral letter submitted before the reference authority, Lordship. Lordship will find the impugn order at page 28, Lordship. Operating portion is at page 29, last paragraph.
28.
28 is the referral letter by the Deputy Commissioner, Lordship. As per Lara Act, he is the collector, Lordship.
Yes.
Through this order, Lordship, he has made a submission under section 65 of the Lara Act 2013, Lordship.
Hmm.
Now, in the last paragraph, the whole issue which is pending before the reference authority, that has been decided by the Deputy Commissioner. Lordship, last paragraph I am reading, Lord Last. In the screening of all facts, it is found that the Ampo village does not fall under the land acquisition for the Italian hydroelectric power, hence not recorded for the land acquisition process. The whole dispute is regarded to this Akobe community land, Lordship. Now, we, the petitioners, are claiming that we are also part of that acquisition land that has been projected to be acquired, Lordship. Further, the representation submitted on so-and-so by Janta Umpe for the reference under section 64 of Lara Act to the award, it is pertinent to mention that the period of the claims to be made under section 64 of Lara Act 2013 to the award is not maintainable. Again, Lordship, here the issue in regards to the limitation under section 64, there is a clause. There are certain limitation that has to be decided when the award is challenged before the reference authority, Lordship. That again has been decided by the Deputy Commissioner, the collector, Lordship, which
This is a
as per
reference-
law, he's not allowed to decide, Lordship.
Is it a reference or rejecting your reference?
Reference matter is pending before Lordship. May kindly come to page 312, Lordship. Since I have been submitting several representations before the Deputy Commissioner to refer the matter to the reference authority, since the Deputy Commissioner was not referring that matter, Lordship, I had to approach before the reference authority under section 64 of Lara Act, Lordship. Now, this is the order, Lordship, 312, Lordship. By this order, prima facie being convinced, the reference authority has directed the Deputy Commissioner to refer the matter under section 65 of the Lara Act before the reference authority, Lordship. Operating portion is at
That will be
314.
determined only it has to be referred and whatever decision he may have taken.
Lordship, here, Lordship,
Commission-
Deputy Commissioner cannot decide the title, Lordship,
No, it will
or the
not-
limitation.
See, it will not guide the reference code. Reference code will have a different, will decide on its own. On the
Lordship,
reference, whether
since-
this is
since-
said or not, doesn't make a difference.
Since already the Deputy Commissioner, it will highly prejudice the petitioners here, Lordship. Now, the same contentions has been taken by the opposite private respondents, Lordship. In their Lordship, they have filed, in fact, they have filed one civil miscase, Lordship, that order I have annexed at 315, Lordship. There, in the civil
So
miscase,
he
Lordship,
made this observation while referring the, submitting the, while making the reference,
Lordship, while making the reference, the DC has made these observations, which is beyond his jurisdiction, Lordship. He cannot,
see, reference court to civil court will not simply go by his observation. You will determine, civil court will determine as a reference court. Just because deputy commissioner has said something, he will not come to that.
Lordship, but then, Lordship, we have apprehension that will be prejudiced, Lordship, and when,
Yes,
My lord, in the impugn order at page 29, I'll not go into the other merits, my lord, but the deputy commissioner has said that the claims is made under section 4 if the award is not maintained since the land acquisition, the period has elapsed.
representation that by citizen for the reference.
Representation submitted on 18/4/2025 by Sri Janta Umpre for reference under section 64 to the award. It is pertinent to mention that the period of claims to be made under section 64 of the to the award is not maintainable since the land acquisition authority has awarded the compensation amount of so and so and approved the so and so on dated 16 February 2016. 16 February 2016 and 2018. My lord will kindly come to when can and who is the authority to make a reference and to entertain a reference. My lord will kindly see section 64. 64. Whether first question will be whether any claims now can be entertained after, if we count it from 2018, he makes a representation in 2025. Section 64 subsection 2, my lord. The application shall state the grounds on which the objection to the award is taken, provided that every such application shall be made if the person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of collector's award. In other cases, within 6 weeks of the receipt of the notice from the collector under section 21, or within 6 months from the date of expiry of collector's award, whichever period shall first expire. Then, my lord, provided further that the collector may, it says the collector, may entertain an application after the expiry of the said period within a period of 1 year, if he is satisfied that there was sufficient cause for not filing it within the period specified in the first provision. Meaning thereby, it is the deputy commissioner who is the collector who will decide on the limitation to accept any
whether
claim.
it has to be entertained or not.
Yes, ma'am.
When did you file your application?
Lordship,
18/4/2025.
Lordship, the award that was passed in the year 2015, which was approved in the year 2018, Lordship, that was subsequently modified since the company got changed, Lordship.
When it was modified, file.
It was recently modified, Lordship.
Award.
Award was recently modified, Lordship. Now, the modified award was accordingly notified to us, Lordship. Then we have put our representation, Lordship. That is within that limitation period, Lordship,
Of what?
of this particular section 64, Lordship.
When it was final award?
Lordship will find that at page 300, Lordship, the modified award,
Which
Lordship,
date?
which was through this circular, we were notified that the award which was passed during the year 2018 was modified, Lordship. There are several orders from the authorities concerned also, Lordship, whereby that award that was passed in the year 2013 was subsequently modified, Lordship. Page number 300, Lordship. Annexure 14, Lordship. 302 is the award, Lordship. Lordship, type copy, Lordship will find it 303, Lordship. On the top, Lordship will see on several dates, the award was modified, Lordship.
300.
Lordship,
This is-
according,
No, sorry, this is regarding collection, disbursement. This is regarding disbursement, sir. When to collect, when to be dispersed to the respective villages.
award is at 312, Lordship. 302, Lordship, 2, sorry. Now, through this circular only, we come to know about this award, Lordship. Award that is,
That cannot be. Compensation as per approval of award by, there is 16/02/2021. And so that February 2018. January 20 award to so and so. There is 3rd February 2025.
yes, that is the latest,
3rd
Date,
February 2025.
Lordship. That is,
When
that is the latest,
you should file
within 6 months, Lordship.
6 weeks. Six weeks. In other case, the applications are listed in grounds on which objection, provided every such application shall be made if the person making it was present or represented before the collector. You are not there.
I was there, Lordship, page number 301, Lordship.
No, when it was,
This was through this circular, we were notified to be present to inspect the award, Lordship. 301, Lordship. Lordship, may kindly see 301, Lordship. Through this
may be
circular,
noted with
first paragraph of 301, Lordship. The inspection of the award amount of respective PFs companies would be made available 16 April 2025 during office hours in the office of the undersigned. We were present, Lordship, accordingly.
you are present
I was present. And then accordingly, this particular annexure to
on 16th April, right?
yes, Lordship.
16th April. Then when did you file the reference?
18 April, Lordship. Immediately after going through this inspection, Lordship, after availing this copy, I've immediately filed it immediately after next day, 2 days, Lordship. Lordship will find my application at 304, Lordship.
Yes,
I'm
it
well
appears
within
to
the
be, you
limitation
have
period.
finally allowed them to inspect. As per section 37 on 25th, when is that?
16 April 2020.
16 April. And the reference is of 18. Yes, learned Additional Advocate General,
Yes.
page
As per-
301. 21 April, 16 April. Because you might have initially passed the award in 2016, but ultimately you have allowed them to inspect on 16 April 2025.
Yes, Lord.
I think that would
But,
be under section 37.
Section, it should be under section this, but this is for collection, but I was referring to that because as per the reference, impugn order of reference.
Now, when you have finally allowed them to inspect on
16 April.
16 April, it would be counted from that day because under section 37, they should be allowed to inspect.
Yes,
Correct, Lordship.
So we'll issue notice.
let notice go.
Lordship, The matter that is pending, Lordship, that has to be stayed, Lordship.
Huh?
Reference that is pending before the learned reference court, Lordship. That matter is pending there, Lordship.
Why? On your reference only this has been, you raised that issue.
Lordship, exactly, Lordship.
See, this reference, it was not referred in fact.
It was referred, Lordship.
No,
Lordship,
the-
kindly, since the reference authority was not referring the matter, Lordship.
Huh? Who has filed this reference?
Lordship, I have filed, Lordship. Since,
Before the reference court.
yes, Lordship. Since the Deputy Commissioner was not referring that matter, Lordship, I had to approach to the reference authority, Lordship. Within 30 days, he was reluctant, Lordship. He was not referring that matter, Lordship. So accordingly, this order was passed to refer the matter, Lordship. Now, while referring that matter, Lordship, this impugn order has been passed.
So which one we have to stay?
Lordship,
Speaking is
the
the-
proceeding that has been, that is pending before the reference court, that
You cannot. You have filed a reference and then
civil miscase that is to be heard on 11 of this month, Lordship.
hmm?
Page number 315, Lordship.
Hmm. So. Hmm. Why we should stay this?
Lordship, since that referral order of the Deputy Commissioner, It's-
See, it's not the deputy commissioner, it's in before the civil court. He has already referred. The civil court has taken cognizance of your application. And the proceeding is going on
Lordship,
your
exactly.
application.
But
What
when,
does it make a difference?
Lordship, while making the refer, he has already decided the title and then the limitation
No, no.
period, Lordship. Now, that
Limitation period to the
That
deputy
might-
collector has the authority to decide. Collector has the authority.
no, Lordship, no, as per
Why?
section 64, Lordship.
See, read this. Wrongly or rightly, he has the authority to.
And then regarding the title also, Lordship, he has decided, Lordship. He clearly says that the dispute that
So
we
why
are
we should
disputing,
stay the proceedings before the civil court, reference court, sir?
Lordship, because the matter which is pertaining to the issue that is being disputed by the other party is that of the Deputy Commissioner's observation, Lordship. They are taking the same plea, Lordship.
We'll simply issue notice. We'll consider on the next returnable date. Private respondents are there.
Yes,
Lordship, on 11, the issue that is decided by the Deputy Commissioner will be decided by the learned reference authority, Lordship.
Hmm?
That will prejudice us, Lordship. Now here the Deputy Commissioner cannot decide the title or decide the limitation period, Lordship.
Limitation period, he can. Collector can. Read section,
But then, Lordship, here
the application shall be so and so, provide the application shall be in other cases within 6 of the 6 months from the date of collector's award, whichever period first expire. Provided further that the collector may entertain an application after the expiry of said period within a further period of 1 year. If he is satisfied that there was sufficient. When this order was passed, 312. 29.5.
29.5, Lordship.
Yes,
my lord, from 29.5 itself, this order, we can presume that they were aware of the award prior to this section 37 inspection. So they have filed a reference, filed before the
We'll say,
Signature.
we'll see, because he filed a reference, he want to get it stayed. He wants that the proceedings before the civil court should be stayed. What can we do? Let them come.
in page 315 also.
Hmm.
After the reference, this was on 9th of June 2025,
Hmm.
the impugn order.
Hmm.
Now, all these days, it's been 2 months now, almost 2 months. He has not approached. Now, there was already a hearing, if my lord will kindly see at page 315. There was an objection raised by the other party. A hearing was done. There was an objection. Now he has come.
Lordship, the order of the Deputy Commissioner, referral letter, Lordship.
Let,
That we have recently obtained from the court, Lordship.
We'll see, we'll consider a prayer on next.
next, since there are
Lordship,
private
since
respondents.
that's civil,
Let it be a short date, madam.
When is the next date?
next date is on 11 of this month, Lordship. Page number
Mr. JJ, like,
315,
counsel for the
Lordship.
petitioner. How many petitioners? One
No, Lordship,
petitioners, huh?
petitioners.
Challenge made in this writ petition is to the communication public reference dated 09/06/2025 by the Collector of the Deputy Commissioner Ibang Bali Anini, by which Weber, while referring the matter under section 65 of Right to Fair Compensation, Transparency so and so, 2013. Has observed that the Ampu village does not fall under the land acquisition for the Italian HEP within bracket 3097 MW bracket close, page 29, huh? And hence not recorded for the land acquisition process. The representation for filed by the petitioner on 18/04/2025 for reference under section 64 of so and so Act 2013 is also not maintainable since the award was passed by dated 08/02/2018. It is the no. The petitioners,
Lordship, petitioners.
claims that claims that they are the owner of the land in Akobe village and the Ambuji Mano clan was allowed temporarily to settle, but later on encroached upon their land. The dispute over compensation, apportionment errors during the land acquisition process for the Italian hydroelectric power project, which began in 2012. It is the contention of the petitioners that the award, although passed in the year 2016, thereafter it has been modified on several occasions till it was finally allowed to inspect on 16/03,
Yes, Lordship.
05,
04.
04, 2025. The petitioners have filed reference application before the collector on 18,
Yes, Lordship. 18.
14/04/2025, which is within the limitation period. Therefore, it is contended that the apart from having no authority to decide the title of the land of the petitioner, the collector has illegally held that the reference application is not maintainable since the land acquisition authority, since the land was, the award was passed on 08/02/2018. As the collector has ignored the provisions of law and failed to consider that the application for reference was filed within a limited period, within limitation period. Under section 64 of so and so. Issue notice returnable by, for which, since Mr. and London Editions as Advocate General entered appearance and exit notice on the state respondent
1 to 4.
1 to 4, no permanent, no exit notice. Who furnished to the so and so. Petitioners to police stage for servicing. Notice upon the respondent number,
Private respondents, Lordship.
respondent number 4 to 5 to 10. 5 to 10.
Lordship,
5 to 10.
yes, 5 to 10.
Within 2 days. Considering. Now, having considered that the collector of the deputy commissioner prime facie appears to have observed has held that has observed with regard to the title of the land and also the maintenance of the reference while referring to the while making reference under section or submitting the reference under section 65 so and so, comma. In the interim, it is provided that reference court may not be influenced by such observation of the collector. Yes, additional AG. We'll say that the observations, the reference civil reference court will not be influenced by the observation of the deputy commissioner. Then in that case, yes, in the interim, no, not in the interim, till returnable date, the proceedings being, what is the number? Proceedings before the authority,
Civil reference number 3 of,
being civil reference case numbers 3 of within bracket DB bracket close,
and
case
civil
number
miscase number 23 of,
public 2025. Civil miss case number
Lordship, that,
and so and so. Shall remain suspended. We'll just say, we'll see.
Obliged.
My apologies, my lord. My lord, the matter before the lordship is against the impugn order passed by the chief estate officer. However, my lord, so far actions of pleading is concerned, my lord, the actions of pleading has not been completed. I have received the affidavit in opposition filed by the respondent number 1 only, and there are 5 respondent, my lord.
Notice has been served or not? Notice is served.
My
on
lord,
respondent.
notice, so far, my lord,
Are they private respondents?
private
Are they
respondent.
private respondents?
Yes, madam. 3 to 4, 3 to 5 are the private respondent, madam.
Hmm. So are they being represented?
So far, my lord, not been represented by anyone.
Notice,
And
notice with regard to justice upon respondent 4 and 5 not yet filed till date.
my lord,
How do you know that when you have not filed the affidavit?
my lord. In fact, if there was taken, so my lord, I will file.
Huh?
I will file, my lord. This in-
What about 3? Affidavit filed on behalf of petition on completion of the service office note, respondent number 4 and 5 in this. Okay. What about 3? 3 is represented.
No, my lord. I think, my lord, this should be 3 to 5 are the private respondent.
Two, lordship, the filed by the respondent number 1 will cover the respondent number 2 also. And
No, no.
lordship, here the.
No, we're on respondent number 3, 4 and 5. 3, 4 and 5. It's- You have said 4 and 5. What about 3?
My lord,
Your application for proof of service is 4 and 5.
my lord.
What
And
about 3?
3 was, my lord, sent through the registered post, my lord. Registered
Whether
date.
that has been received or not? It's a 2024. Oh, service of notice is complete on respondent, however, none has appeared on memo. Justice and upon respondent for the terms of the other thing. Yes, all complete. There's the office note, why? There's the order of because why office note has been, why this has been missed out? 2012 only, last note. After this only there is an order passed by this court. After going to the ATM, the service has been given only, however, none has appeared on behalf of the respondent. In view of this, it is need to be the as regards service. Please to the to list the method service render after me. Why? After this, the note should have been here, that service complete, yes? Service complete,
My lord.
whether they appear or not, once it is complete, what's
Let the matter be taken up for admission hearing on next,
It's
because.
admission hearing, listed for admission hearing only.
lordship,
So then-
otherwise,
And observation, my lord, may be made that if respondent number
What
1 will,
observation, what disposing of your petition?
my lord. If my lord ready, my lord, if my lord
Yes.
is
Are
ready
you
to
ready?
dispose of.
Are you ready?
so this can be taken up because this is an illegal construction and of vendors, illegal vendors in the unauthorized places, lordship, wherein they have obstructed the entryway and common space of commercial plots at Ganga Market. Whereas they have.
It's
said
not a
they-
private land.
Not at all, lordship.
Your only, the ground is that it's a private land.
My lord.
How can this be a private?
Because the my lord, basing on the notice my lord issued, notice as per the my lord order passed by the state officer my lord,
Where it
is
is?
clearly stated that these are the private land.
Where it is?
I'll take the lordship to the page number 33.
Hmm.
This is the impugn order before this
Hmm.
honorable Conman. A complaint has been received from the group of the individual White number nil dated such and such regarding the unauthorized occupation, construction of the temporary illegal instruction within the public premises, obstructing the such and such way, common space and the commercial plot of the Ganga, and thereby hampering the business activities of the shop.
Hmm.
Accordingly, the show cause notice under section 6 of the Arunachal Pradesh Public Premises Eviction Unauthorized Occupation Acts 2003 were issued against 24 unauthorized occupant, vegetable vendor who has constructed a temporary illegal structure within the allotted land of Sri Taro Tagya, Sri Tok Tama, and Bimanat. Madam, these are the private respondent. Madam.
Hmm.
Out of 24 unauthorized occupants, the three vegetable vendor, that is Srimoti such and such, were appeared and stated that they were ready to vacate the premises as and when the owners asked them to do so.
Where you are reading?
My lord, I am reading in the
Out
first,
of
second,
20 unauthorized occupants,
Ta-
three
ta-
against the vendors so and so appeared and stated that they are ready to vacate as and when the landowner asked them to do so.
my lord,
Yes.
when the landowners asked them to do so.
Ah,
Now,
the
Dr.
Instead of-
Bimanatung has stated that instead of his repeated requests and the
Now it
vegetable
considered-
vendors are not vacating his premises, my lord. And now it is the construction of the hospital incomplete and about to start functioning. It is request for the early evictions of the vegetable vendor also harmed Mr. Tarotagia and the Dr. Upon both the parties, it is revealed that the temporary structure erected by the vegetable vendors who is fall under the premises of Mr. Biman Natung, Sri Tarotagia, and Sri Toktama without authority is illegal and liable to be
what
evicted.
does it indicate? It's a private land.
My lord, they are claiming that these lands are the allotted land to this
Yes,
private
it's
land.
a allotted land.
So when matter, if it is the allotted land to the private person, my lord, this cannot be applicable under the Unauthorized Occupant Acts. Because these are private, these are the my lord, private land. Whereas not, this is the public premises, my lord.
Sorry.
Hence,
These are allotted, the public, not public, government land has been allotted to the private individuals on lease. It still remains the public premises. It includes the public premises.
basically, my lord, that's true, my lord. Basically, my lord, what
If
my,
that is true, nothing
what
is
my lord,
dismissed.
my lord, what my projected case is, my lord. This is the complaint on the basis of the private party, claiming that they have been allotted, and now once the lands is allotted, my lord, that premises will no more, my
It's
lord,
a lease.
no more
It's a
come
lease.
under the public
It's a
property.
lease. Allotment is on lease.
My lord.
The owner is still the government.
Despite that, of that also, my lord, still this,
How
my
can
lord,
you-
this no disturbances is, my lord.
Hmm?
Is still today, my lord, we are on these vendors are, my lord, vending, these vendors are selling their vegetables and the others, this, everything is, my lord, on. And my lord, no disturbances is there, my lord. And what the purpose of this hospital constructed by the private person, my lord, this private person, they have already erected their respective building. That is their, my lord. So, my lord, it's appeared that if these are evicted, my lord, this eviction will be going to be carried out on the basis of this interest of this individual person only.
Obviously,
But it is the facts, my lord, that nothing has been disturbed to these private parties, my lord. And we
how
are
do,
still there.
how do you know? There's clear observation by the state officer.
Since the my lord observation was wrong, that is why I am here before the lordship, my lord.
And another technical problem is, this is by the chief or whatever state officer, appeal lies
My
under,
lord,
under section 12. You file an appeal before the deputy commissioner.
my lord. Since my lord, here
The
the
state officer, order of the state, you are challenging the order of the state officer.
my lord,
Appeal lies.
under section 12 of
Huh.
the unauthorized occupant acts, my lord.
Hmm. This passed under section what?
Section 7, my lord.
Appeal lies. Clear cut. Then only you can come. Even if it says that chief state officer
My lord.
is not above the appellate authority under section 12.
Is the deputy commissioner.
Ah. Yes, sir.
My lord, it appeared initially in the para 22, the impugned order state officer was passed earlier on 19/6/2023,
Hmm.
page 22.
Hmm. Yes.
Yes, on the base 22, my lord, it was in the capacity of the ADC cum state officer was already passed.
No.
Thereafter, my lord,
ADC
it's
can be appointed state officer.
My
Once he acted as a state officer,
and now
appeal lies. You are agreed by the final order. 2106/2022, right?
21/6/22. Yes.
Yes.
This is the
This is by
final
the
order.
chief state officer. That even if you raise that this it doesn't fall under it's a travel that can be agitated before the appellate authority. You cannot bypass the statutory appeal provision. Is there any limitation under section 12? Will permit them to avail the remedy.
Yes, Lordship. Otherwise also in the order itself is very clear that Lordship, they are obstructed.
No, issue is more than that. See, once it is allotted, according to him, it's no longer a public premises. So long as it is allotted, I mean, retained with the private individuals. The act applies to a public premises.
Common is there. Is in L shape then the in the.
No, your order says it is the land you have encroached upon the allotted land of these three individuals. It is a government land.
Lordship, if Lordship see the beginning of the order, Lordship, beginning it says Lordship, regarding unauthorized occupation, construction of temporary illegal structure within public premises obstructing the entry exit way of common space of commercial plots.
Then,
Yes, sir,
other than before, final decision,
this is.
final
At the
decision.
Gandhinagar.
Hmm?
And then Lordship, the petitioners, they have said that their vendor area that is in the clock tower.
You see, hence all the 24 vegetables last
Lordship.
para,
Lordship.
second last para, are hereby directed to remove temporary illegal structure from the premises of so and so within 3 weeks.
They might have made the,
Maybe a public premises, but then now obstructing this is the complaint, obstructing the entry and exit way and common space. But ultimately you said, state officer has said, remove from the premises of so and so, respondents.
yes, Lordship.
So this falls under the premises of these 3 respondents. So he has raised a arguable point, but problem is technical. Yes. Let us see section 12. Is there any limitation? No,
My
no.
lord, I have annexed the same is appear in section of page 39, my lord. Page 39 of my petition.
An epistle from Honorable
State officer an order passed in respect of the public premises in the section 5 and 7 of the section 8 and the section 10 to be the appeal officer who shall be the deputy commissioner of district in which the public
This is under
premises.
section 7.
My lord, the section has not been specifically mentioned. If we go through the my lord, the order passed by the
30 days.
Order
from
in
the
the
date
impugn
of
order.
the-
So-called notices are under section 6, Lordship,
Hmm,
of APPB Act, Lordship.
hmm.
Lordship, page 27 in my affidavit in opposition, Lordship, page 27. Support notice is clear here, Lordship. It's under section 6. My affidavit, Lordship,
Saying what? Page,
27, Lordship.
your affidavit.
Yes, Lord. Is under section 6 of APPP Act 2003. Grounds, support notice, Lordship, unauthorized use of constructing illegal structure within public premises, we have said. Obstructing the entryway and common space we have said, Lordship, common space of commercial plots at Ganga Market, Itanagar, thereby hampering the business activities of the shops. Because in this public premise, only they have set up this vending job shops, Lordship.
No, this is impugn order 2106/2020 is passed under which section?
Section has not been mentioned, Lordship, when shortages has been given in Lordship under.
If
section-
after section 6
Yes,
notice is passed, what is the next? What is the next? See, appeal will lie against the order of a state officer passed under section 5, 7, 8, or 10,
My lord.
not under section 26.
yes. Lordship,
Let's see.
otherwise also there is a factual, this one, Lordship.
Nowhere more often legal because it's eviction. Actually, we will go by the will not go into the factual thing. But then eviction matter, we normally go by legal issues.
Lordship, at page 16, she had been allowed to do her Lordship, commercial activity vending at clock tower, near clock tower only, place of vending. But then she have gone to the Ganga, Lordship. This is.
It's okay. They have said so that they will vacate. But that is a factual issue. The legal issue is whether the appeal lies or not. Section 12 talks about the appeal from the orders under section 5, 7, or what, 8 and 10.
Yeah.
It's 6 is silent. And your order appears to be under section 6, directed to remove.
Yes, Lordship. Then Lordship,
Kindly go through it. An appeal shall lie from the order of the state of made in respect to any public under section 5 or section 7 or section 8 or section 10. 4 sections only. And the impugn appears to be under section 6
yes.
when you have issued the notice. Heard Mr. C. Modi, learned counsel for the petitioners. And MS Soins G at the learned addition senior government advocate.
For 1 and 2, Lordship.
For respondent 1 and 2. Non-appears for the petitioners. Non-appears for the respondent 3, 4, and 5. Dispersed services of notice. Dispersed service of notices, huh, Mr. Having considered that the impugn order that is 2106/02.
My lord. 2106/22.
06/2022 passed by the state officer, chief state officer under section, what I said, having considered that the impugn order so and so passed by state appears to be under section 6 of the Arunachal Pradesh Public Premises Unauthorized So and So Act 2003, against which there is no mention of the said section. this, comma, the this court coincides of the view that this court deem it appropriate to admit the petition for further hearings. Is the petition. Mr. The land council for the parties directed to, no, granted 2 weeks time to address the court regarding the appeal. Regarding the orders. Regarding the appeal against the orders of the state officer under the so and so act, huh? Mr. List the matter after 2 weeks. We'll see.
Lordship.
You go through it.
Oh, bless you.
May I, Your Lordship? Your Lordship, in this matter is pertain to the non-inclusion of petitioners in PAF list. However, now the parties came to the amicable settlement and the other party have agreed to include their names in PAF list. So
You want to
matter will-
withdraw?
Yes,
Uh,
dispose of them,
Withdraw.
dispose of them.
Withdraw.
Yes,
MS T Somo London Council for the petitioner submits that she has an instruction to withdraw the petition as the parties have entered into an agreement to settle. The parties have already settled the matter.
yes.
Mr. MS Swens P Sangeeta London State Council is present, having considered that, what I said first line. This London Council for the petitioner submits that. She has an instruction to withdraw the writ petition. As the parties have parties have settled the matter, huh? Not already, Mr. So and so, so and so. Record is here present. The prayer of the London Council for the petitioner is accepted accordingly. Writ petition stands.
Yes.
Dispose upon withdrawal, huh? Next.
Merges of legislation.
My Lordship,
Yes,
Lordship, I am for the respondent number 2, Lordship. Leading counsel Mr. Jibam is in hospital for some family problem, Lordship.
who is in hospital?
Lordship,
Who is in hospital?
his family member, Lordship. I may be allowed to.
Cancellation.
No, Lordship.
Cancellation by LPC.
Yes, Lordship. Yes,
You are for respondent number 3.
yes, Lordship.
You want some time?
Yes, Lordship. 2 weeks time, Lordship.
For, you have filed the affidavit. Have you filed the affidavit?
Sorry, Lordship.
Respondent number 3, my lord, they have filed the affidavit.
File.
Yes,
Yes.
yes. Lordship.
On the prayer of Mr. So-and-so, London Council appearing on behalf of Mr. Who? Mr. Your name is there. Mr. So-and-so appearing on behalf of Mr. Respondent number 3. On the ground that the leading counsel is Jibam is indisposed due to medical emergency and the prayer not being objected and what I say. Medical emergency. legal emergency, huh? Any prayer not being objected to by Learned Counsel to the petition as well as Mr. Alistair of London Additional Advocate General, let this matter be listed up for 2 weeks.
Your Lordship, there is interim,
Interim order passed earlier shall continue.
much obliged.
My lordship,
Yes,
lordship, affidavit hasn't filed, lordship. I need 3 weeks time to file rejoinder, lordship.
you have taken time on. What is this? Today is what, 7? You have taken last time, on the prayer of Mr. So-and-so, Learned Counsel for the petitioner.
Lordship.
Further 2 weeks time is granted to file affidavit in reply.
Obliged.
May I please the Lord?
What is to be done? Affidavit in reply not yet filed. You want to file affidavit?
No, I have already filed, madam.
Who has to file?
Pleading has already been completed, madam.
You have already filed,
Yes, madam.
but there is a office note.
Oh,
Are you sure you have filed the affidavit in reply?
yes, madam.
Have you received the copy? Okay. Although office note dated 06/08/2025 indicates that no affidavit in reply is filed, Mr. You take a Learned Counsel for the petitioner submits that she has already filed the affidavit in reply. To which MSP Pang Learned State Council confirmed the same. According admission hearing,
Hearing, yes,
Admission.
my lord. My lord, I need 3 weeks, my lord.
3 way, huh?
Yes, yes.
3 weeks.
Obliged.
Yes, second service,
Yes,
Rusty,
yes.
where it is? You have filed the affidavit?
It's fine.
No. Affidavit of service. Not MSP, Learned Counsel for the petitioner. Who is this respondent?
It's IO,
Huh?
IO of the case.
IO.
IO.
IO is by name or what? Is it by name?
No, name is SS Jha.
By name? You have made him by name.
Yes,
The petitioner has filed an affidavit with regard to the proof of service of notice upon respondent number 6 by Dusty Mott. Christopher. Where it is? Where is the receipt? Who has received this?
actually we went to police station, but he didn't receive, so we served there in the PHQ.
You have to, Dusty means what? You cannot just serve it in the PSQ.
It's been long, we are serving in the police station, but we never met him in different police stations. He was transferred, but he never received, so we went to PHQ and we served there.
This cannot be proper service.
So
You
what?
find out the address.
Yes,
and
Your Lordship,
serve-
it's
serve
been
Police stuff,
two,
huh?
three-
It's a Supreme Court latest decision. This cannot be. Dusty Mott means you have to serve in person,
Yes.
not in please take next file, huh? So and so. What is it? Last line. Perusal of the next para indicates that the respondent number 6 has not received, no, perusal of the affidavit indicates that the notice has been received by someone in the police station rather than the respondent number 6 himself. In view of the counsel for the petitioner to take precise steps by register post as well as testimony, by a testimony, huh? Within 3 days. For service and notice of response 6, huh? This after 4 weeks. Yes,
My lord, this matter may be fixed for admission hearing, my lord.
why? Have you filed the affidavit in opposition?
No, my lord.
Reply.
No, no, my lord. That's fine.
You don't want.
Yes, my lord.
You don't want to file.
Yes, yes.
Mr. O Dugong, learned counsel for the petitioner submits that he would not be filing affidavit in reply to the affidavit in opposition filed by respondent number 9. Please look. So who else are there? Service all completed.
Yes.
All are represented. All are represented.
Yes. Regarding the all, I'm confused, my lord.
Anyway. For respondent number 2, 3, 4, and 5. Who is for 2? You are for only 9. Service, whether there is a service on upon respondent, other respondents. And Mr. Omodi learned counsel for the respondent number 9. Registered to verify as to whether other respondents are duly served or not, and to put up the report. There's no indication.
Obliged.
This after 4 weeks, 3 weeks,
Obliged.
3 weeks. Heard Mr. So and so learned counsel on the prayer of understanding counsel so and so so and so. For that 3 weeks time is granted for filing affidavit in opposition. Huh? Right. Registry to reflect the name of so and so.